Hey, it's Eli Suter with Suter Law Firm. Just to remind you, I am licensed in Arizona, New Jersey, and Pennsylvania. However, this information is not state specific. Terminology in your state may differ. Also, this is information only, not legal advice. Watching this video is not going to make you my client, nor will it make me your attorney. Okay? Today I want to talk about why it is so important for every adult 18 years and older to have an estate plan in place. Did you know you already have an estate plan? It's not a very good one. It's your state's intestate laws. Okay, these govern when you don't have the relevant documents in place that make up a basic estate plan. What are those documents? Briefly, it's your last will and testament, it's your durable power of attorney, which appoints an agent to handle your finances, a healthcare power of attorney, which appoints an agent to make healthcare decisions for you, and your living will, which is directions about how you want to be treated when you reach the end of your life. If you haven't already, you can watch my basic estate plan video or my estate planning 101, which is the 30-minute video, which will cover this information I'm about to cover as well. So like I said, every state provides a basic estate plan for everyone, but you should not depend on it. Okay, it's going to be expensive and time consuming and onerous for your family to navigate it. And by just being proactive and getting some basic estate planning documents in place, you can save your family a ton of stress down the road. Okay, now I'm going to cover a couple different scenarios. If you die without a will, your family is going to have to decide on who's going to serve as the executor of your estate. If you aren't married, then it's going to fall upon your children to decide or argue about, fight over who's going to serve as that executor. By law, anybody who can serve has to sign off on who is going to serve. And so I recently did an estate where there was like 8 children or 5 children and then a couple grandchildren from a deceased child. They all had the right to serve as the executor. And so they couldn't agree. It took a very, very long time, and it ended up costing the estate a lot of money because they didn't get probate open in time, and the assets sat there, and mom's house almost went into foreclosure while they were arguing over who was going to sign the contract to sell it. They had a buyer lined up for it. So once your family agrees on who's going to serve as the executor, that person's going to have to go post a bond, and the bond's going to be based on the value of your estate. For instance, the estate I just mentioned, where the family members couldn't decide on who's going to be executor, they ended up appointing me to be executor, and to post the bond, it's based on the value of the estate. That estate was only worth $150,000. It was just the house. Mom's house was all that was in it, and the bond for that non-refundable was about $800. Once that bond is posted and probate can be opened, if you don't have a will instructing where you want your things to go, then it's going to be according to the state's plan, and that can be very complicated. If you just have a wife and a couple kids, that's fine. But if your wife has kids by a previous marriage, if you have kids by a previous marriage, if you don't have children, your siblings come into play, your parents can come into play, and your assets may wind up with people that you would not necessarily want to have them. If something horrible happens and you become incapacitated, let's say you get in a bad car accident and you're in a coma or something like that, your loved ones will have to go to court in order to get somebody appointed as a guardian of your estate. This is the person that handles your finances, and this is the person that would be appointed by your durable power of attorney, a relatively simple document to put into place proactively. You would also need to get, it could be the same person, depending on the size of the estate, it may be 2 different people. The court may require that 2 different people serve in these roles. And then the second one is your guardian of your person, right? This is your healthcare agent, the person that would be appointed by your healthcare power of attorney. Finally, if you don't have a living will, these are your instructions for your end of life. It's leaving a heavy burden on your family to not appoint one person and communicate, make sure that person or a couple people a backup healthcare agent. If you haven't talked to people about it and left instructions on how, what they say, when do you want to have them pull your plug, right? Those are very tough decisions for a family to make without any guidance. So it's important that you have a living will. It covers your organ donation, do not resuscitate, those type of situations. And the living will, it talks about in the other basic estate plan video. Your living will is only going to apply or be effective when you are unable to make your own decisions or communicate your own decisions, and you're incapacitated. So without all these documents, it is very expensive, time consuming, and stressful for your loved ones, which is why everyone 18 and over should, at a minimum, have the basic estate planning documents in place. In addition to those obvious reasons why you want to have an estate plan, it's important to be proactive in frankly everything legal, but with estate planning, especially if you, for instance, own a business, either alone or with others. If alone, you need to have a good succession plan in place so that somebody can come in and wind your business up or continue running it to maximize its value, so that it can be liquidated or sold to benefit your estate. If you own a business with others, it's important to have buy-sell provisions in your operating agreement or shareholder agreement, ideally that are funded with life insurance. Having these things in place are going to help maximize the value of your business, whether you're retiring and want to sell your business, or you die unexpectedly, right? And now your family is left trying to find a buyer for your business. If you don't have these things in place, your business could kind of sit there and wither and die on the vine, and any value that your estate might have received for that business asset, that business interest, can be lost quickly. So it's important to have these things in place. Also, if you own property with others, maybe you inherited a gas station with your brothers, you would want to make sure that's specifically addressed in your estate plan to avoid any kind of family turmoil down the road, or issues with that asset. If you have children from a previous relationship, or your spouse has children from a previous relationship, obviously you're going to want to take care of those children as well. If you're likely to have a large estate, I've had people say, I don't have a large estate. I just really want to keep it simple and we don't need a lot of bells and whistles. We are planning for the worst case scenario when it comes to estate planning, and that includes, you dying young wrongfully. Attorneys always refer to somebody getting hit by a bus. In real life, if you got hit by a bus, it's very likely that the bus company is going to end up owing paying out a wrongful death award for killing somebody at such a young, ripe age. So you never know. You could hit the lottery. You can inherit a bunch of money. So it doesn't hurt to put the provisions in your estate plan just in case. It's better to have language in there that you don't ever need than to need language in there that's not there. Let's say you want to protect your assets from future creditor claims, right? You don't want your beneficiaries' inheritance lost to pay creditors, whether they're, your kids run up credit cards in college, get in an accident and get a judgment against them, something like that, or go through a messy divorce. There's ways to structure the inheritance such that those funds will always be there for your children, always be there for the beneficiaries, regardless of how messed up they mess up their own life. You'll know that at least your inheritance is there for them. And finally, if you want to make gifts, give specific things to people, then it's important. Or if you want to make sure, that mean brother of yours never gets anything, you want to disinherit somebody. In all these instances, in literally every situation, especially these, an ounce of legal prevention can be worth a ton of cure very easily. Spending $1,000 or $2,000 on a quality estate plan could easily be the best money you spend. That'd be a great investment, right? You avoid the probate bonds, you can avoid the asset or your business interest losing value, you can avoid massive legal bills that come with doing things the wrong way, right? I recently had a client come to me after the mom had passed, and they had set up, a couple years before she passed away, a LegalZoom trust. Right? It was very cookie cutter, and then they tried to add things to it, added language that conflicted with what the boilerplate stuff from the LegalZoom documents were. It took hours of legal time to kind of figure that out. They ended up funding the trust using a deed that had the wrong dates on it, and so it was more time figuring that out. So again, $1,000 or $2,000 on an estate plan sounds like a lot of money right now, but when you look at the tens of thousands of dollars that you could easily cost your estate without having those things in place, it really could be the best investment that you ever make. So there you go. That is why you should have a estate plan in place if you're 18 years or older. You're grown up now, and these are grown up documents, so it's important to get these in place sooner rather than later. It's like having a toolbox in your trunk. You hope that you never need it, but if you do need it, you're very thankful that you took the time to put it in there and take care of it. So schedule an appointment or a phone call by visiting our Facebook page, or just give us a call, shoot me an email, watch our other videos, and if you have any other legal needs, business law, contracts, real estate, trademarks, etc., give me a call about that stuff too. Okay, thanks.